quite often people get disappointed when certain rights are not fully realized. And the blame is usually put on the duty bearers. But I've always argued that disease has been with us since time immemorial, diseases. But we don't attack hospitals and health centers. Why are people having malaria? Why are people having backaches? The most important thing is if one is afflicted with any given disease, is there a health facility to run to? Now, duty bearers are available to do prevention and protection. Duty bearers do not exist and do not have an enforcement mechanism, especially human rights institutions, to deploy in everybody's home, market, village, to ensure that nobody should be tortured. And I would like to be understood on this. Now, the most important thing for the duty bearers to do is to do what it takes to promote, to prevent, to fulfill, using the available resources, human and financial. It might be practically difficult to, we desire a world free of human rights violations, but since we think differently, some duty bearers and rights holders alike, they end up violating people's rights. But now when it comes to torture, and this year's theme, taking stock of the successes and challenges made, it is important for us to acknowledge that there have been some successes. But also challenges continue to exist. So we shouldn't blame. We are not here to apportion blame, but to discuss jointly how to address, we are here to jointly appreciate our efforts in terms of the achievements made, but also to see how to deal with the challenges. And from where we stand, we've got a robust legal framework for the protection and promotion of human rights in general, but the right to freedom from torture, cruel, inhuman, and degrading treatment or punishment in particular. When you look at Article 24 of the Constitution, it says no person shall be subjected. No person. There is a difference between everybody, everyone, and no person. Those who do drafting human rights documents know this better. So when the Constitution says no person shall be, implying it is really a command from the highest level you can think of. The same is repeated under Article 44, making freedom from torture an absolute right. Under no circumstance should a person be tortured. Now, that is the Constitution. But we went ahead to operationalize those provisions with the Prevention and Prohibition of Torture Act 2012. There are a number of legal institutional frameworks in place. Now, where is the problem? That notwithstanding, the vice continues to happen. Now, it does not change his behavior and attitude. Human rights remains on paper. So the gap is in implementation, and that's what we should interrogate. I don't think we would like now to say here we don't have laws in Uganda that prohibit torture. The UN Cart was ratified, domesticated, and all efforts have been made by government in terms of the legal and institutional framework. Why does torture continue to persist? We are lacking behavioral and attitude change towards respecting human dignity. How we achieve that is what this discussion should focus on. I therefore urge us all to engage in open, honest, and respectful deliberations, and to commit ourselves to developing practical and actionable recommendations that will advance the protection and promotion of the right to freedom from torture and other cruel, inhuman, or degrading treatment or punishment. Once again, I warmly welcome you.
The Convention has stood as one of the strongest global human rights instruments, reflecting universal consensus that torture can never be justified under any circumstance. Unlike many other rights, the right to freedom from torture and cruel, inhuman, or degrading treatment or punishment is absolute and holds no exception, as already mentioned by the Secretary to the Commission. Neither war, terrorism, public disorder, political instability, national security concerns, nor a state of emergency can ever justify torture. That principle lies at the heart of the rule of law. When the word torture is mentioned, many think only of physical pain or suffering. Yet the reality is that it's way broader than that. The Prevention and Prohibition of Torture Act 2012 defines torture as the intentional infliction of severe physical and mental pain or suffering for purposes such as obtaining information or a confession, punishment, intimidation, coercion, or discrimination. Torture therefore exists in multiple forms: physical, psychological, and emotional, and includes severe beatings, electric shocks, sexual violence, burning, deprivation of food or water, forced stress positions, and other forms of physical abuse. It also includes acts that leave no visible scars that cause deep and lasting psychological harm, such as prolonged solitary confinement, threats against family members, humiliation, sleep deprivation, blindfolding, mock executions, and forcing victims to witness the torture of others. These acts do not only injure the body, but they directly attack and dismantle human dignity, destroy trust, and leave long-term psychological scars. Survivors often suffer trauma, depression, anxiety, disability, stigma, loss of livelihoods, and broken family relationships. That is why torture universally is recognized as one of the gravest violations of human rights. Uganda has established a strong legal and institutional framework to prohibit and prevent torture. At the constitutional level, Article 24 of the 1995 Constitution of the Republic of Uganda guarantees freedom from torture, cruel, inhuman, and degrading treatment or punishment. And more importantly, Article 44 elevates this right to a non-derogable status, meaning it can never be suspended irrespective of the circumstances. And our Uganda's ratification of the UN Convention Against Torture in 1986 demonstrated the country's commitment to prevent torture, investigate allegations promptly, prosecute perpetrators, and provide effective remedies and rehabilitation to victims. At the regional level, Uganda is bound by the African Charter on Human and People's Rights, which guarantees respect for human dignity and prohibits all forms of torture, cruel, inhuman, and degrading treatment.
The UPDF, the Uganda prisons, the Uganda police force, and other sister agencies to observe, promote, and protect human rights in execution of the mandate. UPDF has done well on this, to an extent that it has gone ahead and created a UPDF Human Rights Department. This UPDF Human Rights Department is doing well. It has a formal complex desk where there are any violations of human rights, people lodging complaints, and the department goes on and investigates. Now, under the new UPDF amendment, CAP 330, in that UPDF Act, it created the office of the Inspector of Government under the office of the Deputy CDF. This office, the Deputy CDF, is mandated to investigate all acts and violations of any human rights, torture,
and it has been because of very many different reasons. But I would like to begin with the legal framework and the institutional mandate. Like my colleague mentioned, Uganda Prison Service is very careful with observing the laws that govern us. He talked about Article 51 of the 1995 Constitution that gives us the duty to protect and observe rights as we carry out or perform our duties. So we have to stick to since it is a duty that is given to us by the Constitution. Then I'll also talk about our Prisons Act, CAP 325, our prison regulations, and the prison standing orders. They bring out clearly how the staff should respect and observe the rights of the people that we keep. And we are also aligned with the human rights standards. We observe the provisions of the UN Part, the Mandela rules that bring out the standards of prisons. That's something that has helped us to improve as we go along. And how the staff gets to know about this is that we have regular training, human rights training. We have partnered with a number of organizations. Key, of course, is Uganda Human Rights Commission, because it's their mandate. But we also have Uganda Human Rights Center Uganda that also trains our staff.
The UPDF made a policy under the establishment 2021 UPDF establishment, where it pledged the UPDF Human Rights Department with all the investigative roles to conduct the investigations on any violations. Then we have gone ahead and put in a psychosocial department, the UPDF, and the joint staff of political commissar. This one does the counseling for the victims of torture, for our troops, because torture, as you know, our troops, when they go into the battle fatigue, they are tortured mentally, so the department of psychosocial does the counseling, so that we have also established the UPDF compensation committee, the modular compensation committee. This one goes in ensuring that the people that we have somehow acted against the law and tortured them, they are compensated. That committee convenes and ensures that they are compensated, and then we treat them. We have gone ahead of establishing the national fund, UPDF, treatment. Is one of the promotions in human rights. So basically, what we do.
Challenge when it comes to awards. When the commission or the court gives awards, you find that it's a very big challenge to access compensation, whether from the Attorney General or the relevant institutions. And you find that where compensation is given by the institution, these compensations are in installments, and you find that the previous harm that is done to the complainant really is not catered for, as in terms of ensuring that these survivors are fully rehabilitated in the society. I would like to say that access to justice is one step, but we found challenges where even courts of law have failed to understand or assess psychological torture. Psychological torture is a big issue when it comes to access to justice, and you find that it is really very, very difficult to adduce evidence when it comes to psychological torture, which is really a harm to complainants commonly. You know, leaving apart the physical harm, the psychological torture is something that is very difficult to adduce to court as evidence. And this really alters a number of cases that are reported in the relevant, courts of law or tribunals. This is a big challenge that we find. And you find that there is also ignorance. Ignorance in terms of, some judges are ignorant. I would like to state that. Because there is a case that was reported in the High Court, and this case was dismissed simply because the judge could not believe in the evidence produced by the complainant, simply because this person went through psychological torture, and this is a big problem. So there's been weaknesses in terms of, the people we present our cases to. Quite often there are inadequacies in terms of interpreting the evidence that is produced